Yes, Mr. Colvin.
Lords and Lady, the statutory language, does it include Uber's fourfold implication? In all licensing legislation, there are three mechanisms which create obligations and prohibitions. Mechanism one, the Act defines the licensable activity which henceforth will be criminal if carried out without a licence. Simple example, driving without a PHV driver's licence is criminal. Mechanism two, the Act expressly sets out requirements and prohibitions on licensees when uniform rules are considered necessary. Simple example, driver must wear badge. Mechanism three, regulator may impose conditions on the licence in its discretion in individual cases where this is warranted to protect the public. An example, condition requiring a PHV driver to issue a receipt, a very down-home example. But they've got a wide ability to do that, to meet the exigencies of individual cases in a local area. And we're going to see all these mechanisms at work in this Act, and they work together to set a clear framework within which licensees must operate to further the safety objectives of the legislation. On top of that, most licensing legislation sets out express threshold criteria which have to be met before a licence can be issued at all. E.g., is a PHV driver fit and proper, whatever that is taken to mean. It can mean all sorts of things, such as criminality, good behaviour, and so forth. Now, taking these in that order under the 76 Act, contracting is not specified as a licensable activity. There's no offence of failing to contract as principal. There's no statutory requirement on the operator to contract, as principal or otherwise. There's no mandatory condition requiring the operator to do that, as principal or otherwise, and there's no threshold criterion concerning contracting status. So a business model based on contracting is not a criterion for grant, and vice versa. And that is because, and I'm going to take it shortly, but the obligations under this Act involve getting and complying with licences to protect the safety of the passenger. It's an Act about standards in the private hire industry. It's not an Act which concerns itself with detailed matters around contracting. And as a result of that, Uber has had difficulty in these proceedings identifying its location. And again, taking it shortly, in Uber's original declaration, it used the word lawfully, but then dropped it, as the Court of Appeal noted at paragraph 36, because it couldn't point to the law which would be breached by the operator failing to contract as principal. And variously, Uber has argued the Act was predicated on contracting. It's argued that it was necessarily implicit. This is Court of Appeal skeleton, page 2323, paragraph 67, said it was necessarily implicit in the legislation, hence the Court of Appeal's diversion into necessary implication, and so on and so forth. But now, Uber has lighted on that to book a PHV is to contract for whatever service is required. And so it's really saying that hidden in the definition of to operate is to contract, so that booking and contracting are not just coterminous, they're the same thing. And that furthermore, that contract means contract as principal. And I don't mean to engage in cheap advocacy, but if that was Parliament's intention, it hid it so effectively that for half a century, not a licensing authority or government department or tax authority or the industry, or indeed its lawyers, noticed. And the argument didn't seemingly occur till it got here to this court. We say the argument doesn't hold. So let's turn to look at the statutory language. And section 46 is really the root of it. It's core 18, tab 18, page 386. Section 46 is the foundation of the regime. We've looked at it, but we just need to focus for a second on 46(1)(e). No person licensed under section 55, that's the operator, shall operate any vehicle, a private hire vehicle, if the vehicle and driver are not licensed. And really this tells all of us what the point of this legislation is. It sets out the triple lock requirement, and it places the onus of that requirement on the operator to ensure the vehicles and drivers it works with are licensed, and that makes the operator the gatekeeper and maintainer of the triple lock to further the safety objectives of the Act. So if what pitches up is an unlicensed driver, well, the operator's in trouble. That's how this Act works. And then succeeding sections, I don't have time to go into them, but they're all in the case, deal with the sort of things you'd expect this legislation to deal with: insurance, testing, inspection. There's provision for the licensing authority to add conditions to drivers and vehicles to meet local standards. For example, CCTV installation in cars to protect passengers, language proficiency for drivers to ensure everyone understands each other, and so on and so forth. And that whole scheme mirrors the drivers and vehicle licences held by hackney drivers to ensure that the public is protected when conveyed in the car. Now, just before I leave vehicles and drivers behind, the definition of PHV is in section 80, which you've looked at. It's page 451. And in fact, over the page on 452, you can see the definition of private hire vehicle, and it says it's provided for hire. And Uber have relied on that, but it's unremarkable terminology. Plainly, private hire vehicles are hired. I mean, the clue is in the name. But that doesn't tell you whether the hire is required to be between the operator and booker as principals at the moment of booking. Now, getting to where we need to be, which is operators. Section 55(1) is the licensing provision, and that tells one that the operator needs to apply for a licence, and it provides for the grant, provided the applicant is fit and proper.
So page number?
I beg pardon?
The page number, sorry.
Sorry, section 55 is page 402. And I've dealt with fit and proper in my written case. I won't take you to it now, but it's essentially a term which conveys the operator is fit to do whatever it is they're licensed to do. The licensable activity, literally the activity requiring a license, is to operate. And that is the mechanism one activity at the root of the obligation placed on operators. And now we find operate at page 452 and corresponding operator, and it means in the course of business, so we're licensing businesses here, to make provision for the invitation or acceptance of bookings. Now, time doesn't permit me to go through all the case law on this, but could I invite you to look in our case at paragraphs 45 to 50, and that's in the key documents, page, I think it may be 69, but I think the page pagination may have gone awry. It's in tab 3 of the key documents, paragraphs 45 to 50. Might I kindly ask the court just to read paragraphs 45 to 50? It would save an awful lot of time. 69, I think.
69.
It's 110 for the main
I was
one.
told by my learned junior to add 41, and my maths failed me. I apologise. So there's a long line of cases on this topic, but they all amount to the same thing, which is that it's a narrow, strict and technical, and it's not to be given a wider meaning, such as providing a vehicle or making use of it or permitting it to be used. Now, the learning from that line of cases was accepted by the Court of Appeal in paragraphs 13 and 14 of its judgment, and the correctness of that line of cases is not challenged in this court. And what I derive from that is that Parliament's concern was with the triple lock and compliance with the standards. That's where its focus was. And I should add to that even if this concept of making provision for the invitation or acceptance of bookings did mean entering into a contract, it would be a yet further leap to say it means contracting as principal rather than being able to contract as agent for the driver, something which on Uber's case for the first time we hear today the booker can do, but apparently not the operator. Now the reason for the definition of operate is very simple. The customer gets a duly licensed driver driving a duly licensed car, exactly as for a hackney carriage, but in the case of PHVs, the added dimension, the reason for the legislation, is that the hiring comes not from plying, but through this booking with a third-party business, the operator. So that business requires a licence as well. And then, under the licence, the operator has to maintain a record of the booking to ensure that the driver and vehicle they're using are licensed, and so that there's a record if something goes wrong. And those are the means that Parliament chose to protect the public wishing to be conveyed in PHVs. Now, 55.3, page 402, is the next mechanism, which is adding conditions. And in our case, again, I don't have time to take you to it, but the Court of Appeal noted it in paragraph 32. We've pointed out a condition which Sefton apply here, and I hope it helps to answer some of the court's questions before lunch. You, the operator, have a licence. Here's a condition. When you accept a booking, you must make sure that a licensed driver and vehicle gets there. And that's the sort of thing which a licensing authority, as expert regulator in a local context, can do to ensure that public safety objectives are maintained. And if the licensing authority needs to go further, I'm just making it up, shall publish the terms, shall publish maximum prices, shall on request explain to the customer, whatever it needs to do, the authority has got the ability to do it. It doesn't need a sort of instruction, as it were, from courts. I mean, this is the function of the licensing authority to use its powers to protect the public. So those are mechanism 2 requirements.
And the council has got to apply a reasonable necessity test in imposing conditions.
I'm not sure.
Well, it's what it
Lord,
says.
No.
Isn't that what it says?
I'm sorry. Oh, if it considers it reasonably necessary, that's
Yes.
the point. Yes,
Yes.
absolutely.
Yeah.
Absolutely. So I do apologise. I was talking more generally about conditions rather than conditions here. They're phrased in different ways. Sometimes it's appropriate, sometimes it's necessary.
Well, here it's reasonably necessary.
In this case, it's reasonably necessary. But if the authority takes a view that it is reasonably necessary to protect the public, it would be a very brave operator who went off to the magistrates' court and said, well, we don't think it's reasonably necessary at all. The district judge would say, well, why on earth not? It helps protect the public. So it wouldn't be a very high threshold in just operational reality in the industry day to day. Now, there are then mechanism 2 requirements on the operator. Express requirements. Obviously, the gatekeeper obligations under Section 46 we've looked at. Section 56.2 is a record-keeping obligation. And that's
when you accept a booking, does it have to be for a specific vehicle, or can it be for an unidentified vehicle?
Certainly, it doesn't need to be for a specific vehicle.
But there is an obligation, isn't there, to note the details of the vehicle when you accept a booking?
Before the journey starts. Yeah.
Right. So a booking can start off as an unidentified vehicle, and then one is allocated. Is that right?
Certainly.
To the booking? Is that what happens?
It happens in different ways for different people. So with Uber, remember, it's all very easy if it's all apped up. In these days, since 2022, with Uber, they don't actually accept anything until a driver's around, and you're told that Mr. Smith will turn up in his Ford Focus, whatever it is. In my client's case, they say to the customer they'll do their best to look for a driver. And
are they accepting a booking at that point? I just want to understand.
They accept the booking
right
when the driver says, I'll pitch up. And then
So they accept the booking when the driver agrees to turn up?
yes, because
Not when they say to the customer, I'll do my best to get you a vehicle. That's not accepting a booking.
It could be accepting a booking. It all depends. I'm very low.
Well, let's say they haven't at that point identified a driver. They're just taking on. They're just agreeing that they'll try to find one.
Then
they're not accepting a booking.
I would say that they probably are accepting a booking. It's all set out in detail in Mr. McLaughlin's witness statement, and I've given you the paragraph numbers of literally the staging points in the app. But I'm very hesitant to speak for 5,000 private hire operators in the country working under the agency model. But I can certainly...
Well, I'm just really trying to identify what the Act means by accepting a booking.
Yes, accepting a booking is the moment at which the operator says, yes, I've heard you, and I'm going to dispatch somebody to find you. In my client's case, they say, look, we're going to do our very best to find a driver, and at the moment that they found a driver, then a little thing pings onto the mobile phone saying, yes, you've got a driver, and the driver is going to come. At that moment, my client accepts that they've accepted a booking. But in a different case, where it wasn't a best endeavours service, one could see that there'd be a situation where the operator says, yes, fine, it's accepted, and they would come at that moment. So there's so many different factual scenarios, my lord, it's very difficult for me to get to a point of definition. The booking is accepted when the operator accepts that this is a booking and that there is a reservation.
But there needn't initially be an ascertained vehicle.
It needn't be, certainly needn't be an ascertained vehicle. Yeah. And it would be sort of slightly odd if it was, otherwise everyone could just evade everything. I think, well, we haven't ascertained the vehicle.
But at some point, a booking becomes accepted for a vehicle, and then you have to enter that vehicle in your book, do you? If you're the operator.
Absolutely. That's what 56.2 contemplates. So if something goes wrong, the vehicle crashes or the driver misbehaves, the first thing the police are going to want to do is say, we need to see your register. And in 1976, there'd literally be a handwritten register where the operator would be writing down, oh yes, it's John, it's going to the Dog and Duck. These days, it might be more by way of app, but it's essential that when that customer gets into a vehicle, before the journey commences, there is a record of it, and that's a record of booking. So that performs a very important regulatory function, because it marries with the triple lock to ensure that that there is a proper record of what it is which has been booked. And then it continues on. 56.3 are records of PHVs operated by him. 56.4 is production of the licence, and so on. And then in section 57, there's powers under 57.2b and c for the council to investigate the fitness of the operator. And that's there to be read, but it's all about corporate information, again, backed by the criminal law. And when you read those provisions, you can see that what the Act is driving at is the fitness of the operator, the trustworthiness of the staff, the keeping of the booking records, ensuring drivers and vehicles are licensed, and none of it requires the licensing authority to interrogate the contractual arrangements and, on Uber's case, just refuse licenses where the proposed arrangement doesn't conform to a particular contracting model. You're not going to find that in the Act, and as it happens, although it may not influence you as much, you're not going to find it in any of the statutory standards or the national guidance. It is just not there and hasn't been there for 50 years.
Can I just go back to 56.3?
Yes.
Page 409.
Yes. 56.3.
Yeah, does the phrase such particulars of any private hire vehicle operated by him shed any further light on what operate?
Unfortunately,
because it sounds as if operate is being assumed to be operating a vehicle, which you say, actually, if you look at the definition of operate, it isn't.
Absolutely. And that conundrum has exercised judges in the past.
I'm glad I'm not the first.
And unfortunately, what's transpired, and I'm not going to take you to it now, but if you look at Brentwood and Gladen, these are the kind of arguments which have been raised, because advocates have said it must mean something, those words provide the vehicle, because it adds to the definition of operate in section 80, subsection 1. The judges have consistently held that the business of operation is making provision for the invitation or acceptance of the booking, and those words operated by him, it might mean in the stable, in other words, the kind of vehicles that you're working with, that you're inviting or accepting bookings for, but it doesn't mean that the definition of operate means provide a vehicle. Can I just be very clear and careful about this? I would hate the court to think that I'm trying to say to you that the operator is disinterested in the question of vehicle provision. Obviously, that's not true. If the operator sends an unlicensed vehicle, that's trouble under section 46(1)(e). If the operator doesn't send a vehicle at all, that's trouble under my client's license condition 3. But all of this is picked up in the legislation. The question today is whether there's an obligation on the operator to do that contracting and so forth, found there in the statute, and we say there isn't. So whether the provision of the vehicle comes from the operator supplying from his or her own stock of vehicles and drivers, route 1, or the operator not having any drivers and just using one of their drivers under a form of contract, that's route 2, and route 3 is subcontracting. And all of those means were set out by Maxwell Stamp in 4.61 and 4.62, a document which wasn't in front of the court in Uber and Aslan, which the court commented on. Where's the evidence? Where's the history? It was actually there. I don't think anyone realised it at that point. But all of those methods were there at the time and are still there now. So quite exactly how the contracting process occurs is not where the focus of the legislation was. The focus of the legislation was on the triple lock and the standards which emerged from the triple lock. But now I have to turn to contracting. Clearly, and I've accepted, when the passenger is picked up and carried into the vehicle for consideration, there is a contract in place. It's inherent in the notion of hire. Contract is a bilateral arrangement with a mutuality of obligations, and before this Act, there was complete freedom to contract on either side, a common law right, if you will. Did Parliament curtail that freedom by prescribing who must or mustn't contract on either side, and when and how? And we submit it didn't, and we want to look at what it did in 1976 and then come to 2015. We think that's the appropriate order. So Section 56 is set out on page 409, and clearly 56(1) is the key provision. I would almost say it's the only provision which could possibly contain Uber's implication. Can I make 5 brief, obvious points about Section 56(1)? They're also found in paragraph 79 onwards of our written case, and they expand slightly on the points made by Lord Justice Lewison in the Court of Appeal at paragraph 22, but they are all to the same effect.
Sorry, paragraph of your case?
It's at paragraph 79 onwards
79, thank you.
of our written case. I don't think any of these points are rocket science. I hope they're helpful. First, the section is of general application. It applies for the purposes of this part, i.e. not for specific sections of the PHV regime, but for the whole of it. And it refers to every contract. So it's not legislating for a subset of circumstances, e.g. subcontracting. It's legislating for every circumstance. Second, the terminology. 56(1) uses the expression contracting for hire and booking separately. We say they cannot be the same thing or synonymous or connote one another. They're different words used in the same sentence. If they did mean the same thing, it would reduce 56(1)(a) to a tautology, as we've set out in paragraph 82 of our case. Third, the section makes express provision for contracting. So we say there is, in this case, no room for an implication as to Parliament's intention. If the operator is already statutorily obliged to contract as principal, there would be no need to deem that he contracts as principal. Further, it's illogical to suppose that Parliament silently obliged the operator to contract as principal while expressly deeming that he does so. Fourthly, on its face, Section 56(1) doesn't interfere with the contract. It doesn't say who the contract's with. In fact, it contemplates the contract contract could be with someone else. Otherwise, the section would be OTOs. It doesn't specify terms. It doesn't specify when. It doesn't say must be at the point of booking, even if there were no contractual terms set at that point. It seems to preserve contractual freedom and allow for all eventualities. And fifth, it expressly says whether or not he himself provides the vehicle. It therefore contemplates that the person taking the booking and the person providing the vehicle might be different people, which is consistent with case law, that providing the vehicle is not comprised in the term operation. So we say, Parliament saying it doesn't matter who contracts as principal. The contract is deemed to be with the operator who accepted the booking. So it's a neat device. It accommodates this plurality of contracting arrangements, which was there long before the Act, preserves contractual freedom in this complex market while fixing the operator with contractual course in the event of a failed service. And there's logic. If you do call ABC Cars of Manchester and the service is a disaster, well, you're going to be calling ABC Cars of Manchester. And that prevents ABC saying, oh, it's nothing to do with us. Pursue someone else. It's their obligation. It's deemed. And so it's simple, and moreover, over the last 50 years, we're not aware of any difficulties with it. If there were difficulties, it could be beefed up by conditions imposed by the licensing authority. And you've seen that Sefton is not afraid to beef up in order to impose fixed obligations. So standing back from 56(1), we accept the booking is with the operator. The booking of the contract are not the same things. The operator doesn't have to provide the vehicle. And so we say the contract for hire of the vehicle can be with someone else. Otherwise, no deeming would be necessary. But when there is a contract, a deemed responsibility arises. And I just add, for good measure, that even if a booking is a contract, which we say it isn't, nothing in the Act prevents the operator contracting on the driver's behalf, with Section 56 stepping in to deem the responsibility on the part of the operator. And can I just add to that it seems odd that alongside this clearly expressed deemed contract, there's this silent, unarticulated, implied requirement to contract as principal. Parliament was not oblivious to contracts. It hasn't left some big hole to fill. It just dealt with them deftly through this deeming provision. We submit that the Act is concerned with licensing. It's a licensing statute designed to ensure that things go right. Safe drivers, safe cars, proper operators of good character, etc. Record takers, keepers, gatekeepers to the triple lock with the standards of safety enforced through the licenses themselves. Contracts are useful when things go wrong. And Parliament has included this one provision to provide a remedy against the operator as though he is the contracting party, whether he is or isn't. Now, very briefly, there were two other places where the word contract appeared in the 76 Act, and you do have to comb the Act for these references. It's not a contracting piece of legislation. But there's Section 67, which I don't need you to go to, but it relates to hackney carriages taking on private hire work, which they can do because they're not PHVs by definition. And since they do it, by the way, they can contract directly with customers. Parliament never had a problem with drivers contracting. They don't view it as an evil thing in its own right. And the second is Section 75(1)A, which you've also been taken to. And I should just turn that up. Which is at page 440. And Uber say, well, look, there you are. It says contract. And that shows how contracting is at the heart of everything. But actually, what 75(1)A is a general exemption for hackneys, PHVs, and even goods transportation when the contract was made outside the controlled district. All it does is to set a regulatory perimeter at a time in life when it wasn't known whether any licensing authorities would pick up this act and adopt it. So it just said, you've got no business about what happens when the contract happens elsewhere. The provision which deals specifically with PHVs is 75(2), which effectively allows vehicles licensed elsewhere to travel in or through a district. I would just also add about 75(1)(a) that it doesn't refer to booking, contrary to Uber's case in 42.3. Now, can I then deal with subcontracting? And I'm going to take this at quite a lick. Long before the 76 Act, operators would pass on their surplus work to other operators. It was one of the three principal methods of operation recited by Stamp. Parliament recognises this in section 56(2), and it uses, as you can see, conspicuously non-contractual language, undertaking it at the request of another operator. And that came to be known as subcontracting. It doesn't need to be subcontracting in the sense that lawyers would understand it. It's just passing on. And it was described, can I ask you to note, without me taking you there, Lord Justice Hickenbottom in Milton Keynes, which is at page 1070, paragraph 14, explaining that no contract is required. Literally, we have a booking, can you take it on? It might involve a contract and subcontract, it might involve all sorts of things, but the Act just defines it as have a contract, pass it on. But Operator 2 accepts the booking at the request of Operator 1. As you've heard, that was interpreted in the case of D.E.L.T.A as meaning within the controlled district, so some dereg was necessary. And it came in the Dereg Act 2015. Now, the preamble to that Act, which is at page 666, and the explanatory notes at 2328 make it clear the purpose of the Act is to reduce burdens on business so as to allow bookings to be passed out of district. And that casual language in 56(2) is carried on in 55A, 1, arrange for another person to provide a vehicle to carry out a booking. And this is what Lord Justice Hickenbottom was talking about. It's just passing on. It's not a classic subcontract.
Referral.
It's a referral, exactly, my Lord. But then you can see that the word subcontracting is used in 55A1A, where it says, and the subcontracted booking is accepted in that district. That must mean the referral. It's just how the industry came to use the word subcontracting. So this phrase, arrange for another person to provide a vehicle, appears twice. The expression subcontracted booking, referring to that, is used 7 times. 55A2 says it doesn't matter whether subcontracting is permitted by the contract. I'll come back to that. And then 55A3 and 4 point to subcontracting to yourself in another district, which obviously isn't legally possible, but that's just the expression Parliament uses. And Lord Justice Hickenbottom dealt with that at paragraph 42 of his judgment. So from that we get these propositions. Starting point 56(2) contemplates referral, whether or not contractually. The D.E.L.T.A Act is deregulatory. It was intended to widen and not narrow options. And the language of the new provisions is loose, dealing with cases where there's a contract and where there's none, which Lord Justice Lewison pointed out at paragraph 30. But against all that evidence, Uber light on the use of the definite article in one subsection. And the Court of Appeal described that as what Uber described as the high watermark of its case. And for brevity, we just adopt what Lord Justice Lewison said about it in paragraph 30. This one use of a definite article in one subsection of a subsequent deregulation act concerning subcontracting, surrounded by pointers that an actual contract is not required, cannot found a statutory obligation to contract.
Which is the definite article?
I beg pardon?
The contract.
Oh, I see, yes. The contract in subsection 2.
Yeah, it's that word, the. If it had said then the point wouldn't have arisen. So the Lord Justice described that as a slender peg, and I probably can't improve on that. So that's subcontracting. Can I deal very briefly with some practical consequences? We set out a whole raft of practical consequences at 115 and 125 of our case, but I'm not going to take you to them. Can I just mention two implications one way, one implication the other way? Firstly, the person making the booking might not want to enter into a subcontract, into a contract, for whatever reason. They're a restaurant calling a cab for a diner. They don't want to give the diner's name or agree the details or anything of that sort. The suggestion is that to make a booking, they have to, which would appear to be an interference with their freedom. If they don't want a contract, does that mean that the operator must refuse the booking? Or
there's two stages always to the argument. One is whether there's any contract, and the other is whether it's to provide a vehicle, isn't it? The important point is whether it has to be, if there is a contract, to provide the vehicle, or whether it could be some other contract of a different kind.
There's a regulatory obligation to provide a vehicle. Whether there's whether it results in a contract as recognised by lawyers would depend on offer acceptance, consideration and so forth. And the courts have always wanted to be slow to superimpose contractual concepts on this legislation, which is about booking and the standards under the Privilege Law. But certainly, and I'm not resiling from this, the operator who accepts a booking can't wash his hands, and if he tries to, he's going to have his tail bitten by the licensing authority, which has its abilities to enforce. But on the Uber's case, with all their expressions such as indefeasible and so forth, they're looking for a sort of certainty of contracting at the point of booking, and that just it doesn't accord with the reality. It might accord with Uber's reality with their app, but it doesn't.
Well, I find it quite difficult to accept that there isn't any intention to create any legal relationship when a booking is accepted. But I find it much easier to accept the proposition that it may not be a contract to provide a vehicle. Might be to do best endeavours to find someone who will provide a vehicle.
I hate to embark with verbal fisticuffs. I mean, I totally accept that an operator, even though included in the definition of operate isn't providing a vehicle, it would seem odd that under this regulatory scheme, an operator can accept a booking and then just turn his back.
Isn't agreeing to do anything.
But there would be, I'd simply say there would be regulatory consequences, and it's not helpful necessarily to analyse in terms of contract. But if that's the way the Lord's mind is going, I don't want to try and dissuade.
Well, you don't even need to deny that there may normally be a contract arising of common law between the person who makes the booking and the company that accepts the booking when a taxi is ordered. I mean, the only point you have to make is that there isn't a contract imposed by force of law under the statute.
Well, that's precisely so. And if, in fact, every company in the country was able magically to contract for the journey at the point of booking, and every passenger wanted to do that, but there was one company which cared enough to send leading counsel to the Supreme Court, say, but they wouldn't be in business anyway. So we entirely agree that that all we have to show that it's not there by force of law. It's not there under the statutory provision.
Or rather, doing it without an immediate contract for hire is not prohibited by the law. I mean, this is all about whether what is absent statute open season for people contracting or not contracting, however they like.
Yes.
It's all about whether doing it other than by an immediate contract for hire is prohibited by the statute.
Yes.
Isn't it? It's not so much whether the statute prescribes that there is a contract, it's whether it says you can't do it in any other way.
Yes, absolutely. I mean, this morning I had to get here and there'd been a fire in the electrical box at my local station. And if I'd needed to come here by private hire and the operator was like, oh, look, Mr. Conlon, we'll do our very best. I'd say, well, that's not good enough. I really want a contract. And I would have stuck out for one. So there's a little bit of consumer choice being exercised there, but they're not prohibited by law from setting up their business in that way.
No.
And then the second point is that if the operator must contract as principal, presumably that means the driver is prohibited from contracting, which is something they'd done long before this Act was passed, earning an income, paying tax on it, with the blessing of HMRC. And if that right was to be removed from them, you would have looked for some clear language, but there is no language. And just, I know you'll be familiar with these cases. Firstly, the case of Ocadina, page 1104, paragraph 45. This is Lord Justice Underhill, actually in a contracting case, saying it's a healthy principle that the court should be slow to give a statute an effect which is not expressly stated. Parliament should say what it means. And that sits, we submit, alongside Lord Nichols.
So what is the reference in that case?
It's paragraph 45, page 1104.
1104 is the start, I think.
1104 is the quote.
Not in my
Would you
bundle.
like
No.
You like the actual reference? So sorry. CB 48. Yeah, it starts.
Well, 1104 is the start date
It
for me.
starts at 1104.
Yeah, it's page 1118, the dictum.
You're quite right. So sorry. And yeah, paragraph 45, page 1118.
Thank you.
And we say that sits alongside Lord Nichols. I know this is very familiar territory to you, in Spaff Holmes, which was cited in O at page 1320, paragraph 29, by Lord Hodge, that citizens should be able to understand enactment so they can regulate their own conduct accordingly and should be able to rely on what they read in an Act of Parliament. And I just say briefly, it would come as a surprise to several 100,000 drivers to learn that they'd been acting illegally for 50 years. And we say if the common law had been changed in this respect, some clearer language would have been needed. Can I then very briefly deal with Uber's case about the spectre of the non-arriving vehicle? And because all of its alleged concerns regarding contracting are answered by Section 56, what chiefly remains is this proposition that unless there's a contract, the passenger is unprotected against non-arrival. And it says that's a lacuna in protection. We say there's no lacuna, and the solution brings no protection. First, if the non-arriving vehicle is a concern, the licensing authority can make a condition. Sefton has made a condition. Second, it is a licensing regime, and so the principal recourse is through licensing enforcement. But thirdly, in the real world, there aren't always drivers available. So how do you deal with that? Well, my client says to customers, look, we're not making a guarantee, but we're going to do our level best to find you a driver. And it has done that for 50 years without anyone getting upset about it.
I doubt that.
I beg pardon?
I said I doubt that.
Well, the customer...
That's quite a bold claim.
The customer at least knows, when standing in the rain, that we haven't found a driver. We're going to try to find you a driver.
Yeah.
And what actually happens, if I can come back to the real world, is the customers are free to book multiple vehicles, and often do. And then if a hackney comes by, or the first hire that comes by, that is the way people behave in the real world. And that's not an issue for my client at all. It says they're going to try and get them there. In the vast majority of cases, they get them there within 10 minutes. But if they can't, they can't. They've done their best. In Uber's case, it's been identified, they do contract at the point of booking, but then just reverse out, reportedly without compensation if they can't get somebody there. So I don't criticise Uber for that, but it's just the reality of the real world. What no interpretation of an act can cure is the situation where at a specific moment there just isn't a driver available. Now, in similar vein, Uber says, well, the customer could have terms forced on them by some unethical driver. In reality, in 1976, private hire contracts were for a journey at a price per mile or overall. And in 2025, my client, as a responsible licensed operator, sets maximum prices per mile and will tell customers about it. And if it didn't, then it's a licensing authority can make conditions to say that's what they've got to do. And if drivers started imposing unwarranted conditions, then it goes to their fitness and propriety as well. So, conclusion on the statute, we say that licensing is prospective, it sets obligations subject to regulatory oversight, and you can't contract out of anything the statute says. The contract is remedial It adjusts economic rights where there's been a failure, and Parliament has provided a remedy to achieve that. Finally, very, very brief words about Maxwell Stamp and the London legislation. Maxwell Stamp status, paragraph 72 of our written case, I know this is familiar territory, we set out Lord Hodge's analysis of the principles of statutory construction in the case of O, and in particular the secondary role played by external aids. And we say that, following that, the meaning of section 56.1 is not displaced by anything said in Stamp. The Stamp can't change the meaning of the word every in section 56.1. Stamp's mischief was an unregulated private hire sector, which was cured by the triple lock. And when it came to contracting, Stamp made a number of suggestions. We've set them out in our case at paragraphs 148 to 149. They weren't all identical, but one of them was deeming. And so Parliament obviously looked at that, or so it appears, and it just cut through all of that complexity with a general deeming provision. Regarding the London legislation, we submit it's not a tool for construction of the 76 Act, but had Parliament wanted just to replicate the 76 Act, it could have done so, but didn't. There are many differences between the two pieces of legislation. They are summarised in 154 and 155 of our written case, and also in 63 to 65 of Visu's case, but perhaps most importantly, as the Court of Appeal identified, no deeming provision. And there are other differences as well.
You mean no?
So there's a for the avoidance of doubt.
So what for the avoidance of doubt does is to say this is the true position. What the deeming provision does is it creates a statutory fiction. So and they are clearly not the same sort of thing. They might cover some of the same territory, but for the avoidance of doubt, it's just to let you know this is the position. A deeming says even if it's totally false, it's true for the purposes of this statute, as was identified by Lord Justice Lewison in our case. But the London dichotomy was whether the operator was obliged to accept contractual responsibility or whether the operator could just shuffle it off to the driver. And the court said, well, the operator's going to have to accept responsibility. But under the 76 Act, if the operator does that and tries to shuffle it off onto the driver, it just boomerangs back. The operator has responsibility under the deeming. So I'm asking the court respectfully to construe the 76 Act. It might be neat if the acts were construed in the same way, but that shouldn't change the ordinary approach to construction. As for the declaration, I've already talked about the changing declarations during the case. It's common ground the declaration made by Mr. Justice Foster is inappropriate, but we'd go further and advert to what the Court of Appeal said about the inappropriateness of making a declaration in these general cases untethered to particular facts, as set out in paragraph 36 of the judgment. I'm very much obliged to the Court, both for giving me the chance to get through that, but also for its questions, and that completes my submission. Yes.
Thank you, Mr. Corvin. Mr. Gourier.
Just ask Mr. Corvin to let me have his stand.
Court stand.
And looking at the time as wicketkeeper, I was about to take off my pads, but there's something left for me to do.
Too many cricketing metaphors.
May I ask the Court to take our written statement as read and just pick up some things that have been said in the course of argument. In my submission, the key to understanding the statutory regulation of operators lies in the definition of operate, which the Court has heard repeated again and again. It is making provision in the course of business for the invitation or acceptance of bookings for a private hire vehicle. Making provision otherwise than in the course of business is not regulated. There are certain charities giving palliative care, for example, that would be operators in the transport arrangements they make, were it not for the fact that they're not operating in the course of business. And so it is the business of inviting and accepting private hire bookings that is the target of the regulation. And the operator's regulated activity runs its course up to, but no further than, making a record of bookings that it has accepted. And that takes place before the commencement, must take place before the commencement of any journey, and even takes place before the provision of any vehicle. And thereafter, other than being required to produce his license on request, the operator drops out of the regulatory scheme. And that is, if not illustrated, supported when one looks at section 46 of the Act, the offences section. The use of unlicensed vehicles as a private hire vehicle is the owner's responsibility, not the operator's. The employment of unlicensed drivers, again, is the owner's responsibility, not the operator's. It's the owner of the vehicle who has to report any accident that materially affects the safety of the vehicle. And so the scheme, I'm describing it coarsely, but the scheme at the moment shows us a demarcation between what the regulated activity of an operator is, making provision for the invitation or acceptance of bookings, and the hiring and the use of the vehicle that takes place thereafterwards, in respect of which he plays no part. Booking isn't defined by the 1976 Act, and so obviously must be given its normal meaning. The ordinary English usage of the word booking is a term to describe securing goods or services for the future. And a booking, in ordinary English usage, may be of many different kinds. I may pay for the privilege of securing what I want to secure, or I may not have to pay. The booking may give me a right to the thing that I have secured, like a theatre ticket does, or I may have no right. If I book a dentist's appointment and turn up and am told it has to be rescheduled to another day, I have no right to insist on it. If I book a delivery slot for online purchase of groceries, something that some of us did for the first time during COVID, but I book a delivery slot, I have no right to it. I may or may not get it, but I have no right. So the use of the word booking covers a wide variety of circumstances. It may be that the booker has obligations. For example, if I book a table in a restaurant, the restaurant may want my credit card number, so that if I don't turn up, I'm penalised in some way. If I book a private hire vehicle, depending on the arrangement between me and the operator, I may have an obligation to be there when the private hire vehicle turns up, so that I don't waste the driver's time. There is nothing in the 1976 Act that mandates that a private hire booking must be of one kind or another. It just speaks of a booking. A booking isn't a contract of hire. The two are differentiated in section 56(1), treated as different things, distinct things. But that doesn't mean to say that a booking and a contract of hire can't be entered into at the same time. If I book a vehicle to pick me up at a station and take me to my given address for an agreed price, I am both booking the vehicle to meet me at the station and I'm entering into a contract for the hire of that vehicle, under which I agree to pay the price. On the other hand, if I telephone for a car to meet me outside the Red Lion, and I say, there may be as many as 5 of us, I don't know, and where we go is something we'll discuss with the driver. There'll be 5 different destinations. I've booked a vehicle, but by no means have entered into any contract of hire. If I ask for a vehicle to be available to me on standby, I say, can I please, and I'll pay for it, can I please have a vehicle ready, if needed, at 3 o'clock. 3 o'clock arrives, and for whatever reason, I no longer need the vehicle. I've undoubtedly booked a vehicle, but there's been no contract for the hire of that vehicle. So the miscellany of circumstances in which a booking of a private hire vehicle may be made, and Parliament has not mandated or prescribed any of them. The sole concern, I suggest, of Parliament is that The journey that takes place should be the carriage of a passenger in a licensed vehicle, which is therefore safe and is inspected and all the rest of it, driven by a licensed driver who is qualified to drive private hire vehicles and is licensed and regulated accordingly. The acceptance of a booking, I respectfully agree, connotes an agreement of some kind. The question is, agreement to do what? When you accept a booking, I think my Lord Gleggett suggested it this morning, you agree either that you will provide the vehicle or you will arrange for someone else to provide it, and that must be so. But that falls far short of entering into a contract for the hire of the vehicle.
Well, it may be a best endeavours obligation.
Yes, as D.E.L.T.A say.
Yeah.
Provision of the vehicle is not a regulated activity. I do maintain, in spite of what Mr. Ward has said, that any person may provide a vehicle. What the law requires, or the statute requires, is that what is provided must be licensed and driven by a licensed driver. This area of law is bedevilled by the careless use of language. It is said repeatedly that a licensed operator may not use vehicles that are licensed by another authority. That is an inaccurate way of describing it. A licensed operator may not make provision for the use of vehicles that are licensed by another authority. If his modus operandi is shown to be the regular use of vehicles that are licensed by another authority, the offence he commits is making provision for those vehicles, not the use of them. Section 46(1)(a) deals with the offence of using an unlicensed vehicle, and that is an offence committed by the owner of the vehicle. Section 56(1) recognises that a person other than the operator who accepts the booking may provide the vehicle. It doesn't permit it, it just recognises that that takes place. Section 52, which is about record keeping, recognises that a licensed operator may undertake a booking at the request of another operator. 56(1), the provision of a vehicle, and 56(2), undertaking a booking at the request of another operator, are not the same thing. But each of them, over the years since the 76 Act, has in one case after another been given, I just mentioned the careless use of language, each of them has been from time to time described as subcontracting a booking. Not subcontracting it at all. Lord Justice Hickenbottom, I suggest, was absolutely right when he talked about it as transferring a booking from one person to the other. The 1976 Act simply does not describe either of those scenarios as subcontracting. It's regrettable that subcontracting slipped into the language. One can understand if one traces through the 1998 Act in Section 5, one can understand how the Deregulation Act in 2015 borrowed the language, but it's regrettable that it did, because what it provided for in Section 55A, although it's called in the heading subcontracting, simply refers to when another person providing a vehicle for the performance of the contract. It's noteworthy that Section 5 of the 1998 Act is in terms of a prohibition against somebody else providing the vehicle unless in the terms that are permitted. Under the 1976 Act, as amended, there's no prohibition. It simply says that somebody may provide another vehicle, to complete the booking, and then give circumstances in which that is permitted.
I asked Mr. Colvin what operated by him might do by way of shedding light on the concept of operate or provide in section 56(3, and he pointed me to Milton Keynes and said it really just means having the relevant vehicle on your panel as one of a number to which you might go to allocate a booking.
Yes, I touched on this in relation to section 46(1)(e). the prohibition against an operator, it uses the same expression, operating a vehicle that is not licensed. And since operating means making provision for the invitation or acceptance of bookings, both those uses of operating a vehicle must mean that the person must not make provision for the invitation or acceptance of bookings that are not, of vehicles that are not licensed. Operating a vehicle is making provision for the invitation or acceptance of bookings for it. It has to be that. It's unfortunate language, but because operate is defined as meaning what it does mean, operating a vehicle cannot mean anything else other than making provision for the invitation or acceptance of bookings for that vehicle.
That would have to encompass actually accepting a booking, wouldn't it? If you accept a booking for an unlicensed vehicle, then you'd surely be in breach of the regulatory obligation.
It need not. It's likely to, but need not. If, for example, supposing I book a vehicle to take me to the airport urgently, I need to be there, and my operator lets me down, I happen to know that a neighbour of mine is a licensed owner and driver of a licensed vehicle. And I just telephone and say, can you help me out? And he says, yes. There is absolutely no reason in the law why he should not be permitted to do so. He's accepted the booking, and he's not an operator. If he makes a habit of doing that, one can quickly say, no, you're making provision.
I see.
That it would be a question of fact and degree in each case. But certainly a one-off. My neighbour says, I've never done this before, and I'm never going to do it again. He certainly isn't making provision for the invitation or acceptance of bookings, but he has accepted one.
I mean, if you accept it on a one-off basis, why aren't you making provision for the acceptance?
It would allow somebody to bypass the requirement for records to be kept and so forth.
But if that is a correct interpretation of the law, that would be for Parliament to mend that gap.
I mean, it sounds rather like the St Albans case, you know, where again it wasn't being done as a regular business by the wife, but never called.
But as your Lordship said this morning, in that case, the vehicle provided wasn't licensed. It was being driven by a non-licensed driver.
Nor was she, yes. No.
Yeah. But just pausing, my difficulty with the operator that's let me down ought to be capable of being solved by my getting in touch with my neighbour who's a licensed driver of a licensed vehicle. The mischief of the Act, apart from the question of record keeping, but the mischief of the Act it does not arise. I'm being driven by a licensed driver in a safe, licensed vehicle, and I need to get to the airport, and I haven't got an operator.
Can I just ask if this particular area of inquiry is a little bit like angels on pinheads, in the sense that, I mean, you may or may not know the answer, but is there a widespread practice of PHVs owned by a person who is neither the licensed driver nor the operator working in the industry?
Yes. People provide a vehicle breakdown service. There are firms that simply own licensed vehicles. They don't drive them, they don't receive bookings, but they will provide them where somebody else who is a licensed operator has one of his fleet breaks down. The firm that I've spoken of can provide a licensed vehicle, and some firms provide a licensed vehicle and driver. But certainly they can provide a licensed vehicle, and they exist in large number.
It's a sort of reserve fleet of licensed vehicles which can be made available to operators whose own vehicles break down.
Yes. And sometimes it can be a limb of the operator's business as well, a separate company. But big companies do set up a vehicle-owning limb of their operation to do just that, and others rely on others to do it altogether.
Right, okay.
I'm trying to glance through my notes, my Lord, to see what of my written submissions Mr. Colvin hasn't plundered, and I can't immediately find it.
Well, do you perceive there to be any difference between your position and his? Is there something we need to be aware of where you're taking a different line?
Not a materially different line, no. I might have expressed it differently with respect.
Right. What I had in particular in mind was the 56, for the purposes of this part of the Act. D.E.L.T.A accepts that the deemed contract that that you get is just as good as far as the passenger or the customer is concerned as a real contract.
Yes.
And I'm wondering whether we can take it that you agree with that, or whether we have to deal with a different case on your part.
I'll put it my way and we'll see whether that's agreeing or not. Section 56(1) begins, for the purpose of this Act, every contract for the hire of a vehicle. So we're talking about a situation where there is.
Yes, where somebody has turned up.
There is a real world contract.
Yeah.
And it then says, shall be deemed to be with the operator who accepted the booking. So we have a real world contract, and then the statute says there is contractual liability in that real contract in the operator who accepted the booking. If that is how Mr. Colvin put it, I agree with him.
So the contract is not with the contract is formed with the driver, but is deemed to be with the operator.
Many
as well.
Maybe.
As well, or only with the operator?
It has to be as well. And the contract may be formed with the driver, but as I said a moment ago, the contract may be made with the operator.
Yes.
It's entitled to make it.
And so that's a real-world contract.
Yes.
And whatever, I think Mr. Colvin's position was that whatever contract of hire is made with anybody, you've got the rights under that contract against the person the operator who accepted the booking.
Yes.
And you agree with that?
Yes, I do. And also I agree with whatever the public safety arguments are. I think I expressed this, or we expressed it in our written statement, that a contract that is made, I'll start again, if the declaration is good law and the operator who accepts a booking has to contract with the person who makes the booking, but the person who makes the booking has made it for somebody else, that somebody else has no protection in public safety whatsoever if he or she is left stranded, because there happens to be a contract between the operator and the person who made the booking.
Unless the person who made the booking was acting as agent for the passenger.
Yes, but otherwise, if he wasn't acting as agent for the passenger. I don't know whether...
But everybody seems to agree that that's a question of fact that depends on what happened on the particular contractual analysis in any given case. There's nothing that the Act says one way or another about that.
Yeah, and what I've done, I hope not too inelegantly, was trying to scoop up some of the points that were raised this morning, and I thought that I might be able to assist with. But I mustn't, in so doing, neglect the fact that the main thrust of our case is that there is no statutory language capable of being construed to impose a requirement on the operator in the terms of the declaration.
As I understand it, you say two things, don't you? Section 56(1) doesn't turn into a contract for hire something which a common law is not a contract for hire. And equally, nor does it prohibit making or accepting bookings otherwise than in the form of a contract for hire.
Exactly.
Yeah.
And the parties are free to contract in a variety, a huge miscellany of different permutations of ways.
As I understand, is all set out fully in the next English report.
And I did somewhat thinking that I was running out of time, gallop, and have left myself far more time than I needed. But unless I can assist, those were the additional submissions that I wished to raise.
Yes, thank you very much, Mr. Villiers. Mr. Ford.
Thank you, my Lord. Lord Legger asked Mr. Colvin what he thought the meaning of acceptance was. And I noted down this answer. Accepting is the moment the operator says, yes, I've heard you, and I'm going to dispatch someone. There is a reservation. That is a contract of hire.
Well, not necessarily, is it? I mean, it depends what exactly it might be. But you might just be, as we've been discussing, in principle, you might be saying, I'll use my best endeavours to
that is a qualified contract of hire, as opposed to a strict contract of hire. That's all it is. I want a car to be there at 1 o'clock to take me to the airport. Yes, to use Mr. Colvin's word, I've heard you, I'm going to dispatch someone, will use my best endeavours. It's a qualified contract for hire, it's not strict.
Well, what you call a contract for hire is what I would call something that isn't a contract for hire. A contract for hire, as you want it to be understood, is an undertaking to provide a vehicle to carry a passenger to a destination.
Or as Mr. Colvin would have it, to use your best endeavours to provide a vehicle to take a passenger to its destination. That's just a qualified version of exactly the same contract. And at some point one might say, if all you've said is, well, I'll use best endeavours to find a driver, I'll come back to you, you haven't yet accepted the booking. It's when you say, yes, there is a reservation, that's when the booking is accepted. You might say, there may be a model where you say, the first thing I've got to do is find a driver. Once I've found a driver, I say, yes, there is a reservation. That's when the booking is accepted. Before then, you're simply fielding an inquiry. Mr. Gourier posed a slightly different version of this argument. He said booking is the securing of goods and services for the future. We agree. If it's a PHV, it is securing the hire service. Then he said, well, a vehicle might be asked to be on standby. Again, there may be questions of fact about whether or not a booking has actually been accepted. But if a company has been asked to reserve a PHV all day for journeys, destinations and times to be accepted, it has been hired. If there is an agreement that the PHV will sit all day in the car park with a driver, that is a contract of hire with destination and duration still to be determined. Of course, in the law of contract, at some point, a contract will become so uncertain as to be void. Or it may be that nothing has yet been agreed. The company may say, well, I've got plenty of drivers today. Let me know when you want to take a ride. I should have someone. That's not accepting a booking. Accepting a booking is saying the driver will be there waiting for you whenever you decide to come out of the museum or whatever it is. Mr. Gourier said, well, the operator just drops out after recording the booking. But that, even on the respondent's case, disregards the deeming provision in section 56(1) altogether, that at the very least makes the operator responsible for the performance of the contract. And indeed, Sefton's own conditions exemplify the fact that conditions will deal with, for example, complaints, and that's condition 7 on page 2017. As to non-arriving vehicles, it is the respondent's case that they are simply not obliged to perform the booking, unless they're operating in one of 300 district councils that have chosen to impose a relevant condition. And of course, inevitably, given the nature of these proceedings, the only one you have in front of you is Sefton. Mr. Colvin said, well, the booker might not want to enter into a contract. Well, we're not saying that they have to, but we are saying that if you make an offer and it is accepted, there is a contract. The terms of the contract may well provide for cancellation on either side or both. Then turning to the deemed contract, Mr. Colvin said, yes, it is a real-world contract. Mr. Gourier associated himself with those submissions. And they need to say that, of course, because they need it to be enforceable in private law in order to suggest it helps meet the public protection objectives. But this morning, before lunch, Mr. Colvin tried to row back from this, or perhaps more fairly have it both ways, when he said it wouldn't apply for other purposes, such as employment. Well, either it is a real-world contract or it isn't. He said, well, it's for a regulatory purpose. And he couldn't identify the regulatory purpose. We agree, it is for a regulatory purpose, which is to secure public protection but through the existence of a real-world contract to supply transportation services. Where we don't agree is it can arise only at such a late stage. Unlike Mr. Colvin, Mr. Gourier said who this contract would be with. He said it would be with the driver as well. We're still left with a great question mark about on whose terms and what terms those would be, and indeed in the case of the driver, whether the entire contract might be just implied. Maxwell stamp. Mr. Colvin said Maxwell stamp set out the different models. We agree. But it also expressly deprecated what it called the casual operation of the agency model. And that's on page 1751 at paragraph 524. And it made clear that the new scheme it proposed would only be, under which it would only be possible to hire a car by making a contract for its hire with a responsible operator. And that's page 1760, paragraph 6.23. Both of those paragraphs are quoted in our written case.
So 1760, paragraph what?
I'm so sorry, my lord. It's 1760, paragraph 6.23.
Thank you.
Now, Mr. Colvin also gave all sorts of examples of factual complexity. There are lots in his written case as well about exactly who made the booking. Of course, the facts can be messy. Most of his examples are easily seen as contracts made by agents on behalf of principals or factual variants about when the booking is actually accepted. But it's important to keep in mind, on their case, an operator is free to contract to provide hire services. Indeed, both the respondents have operated this merchant model. And if I can give you the references, for Visu, it's page 2075, paragraph 13.1. And for Delta, it's page 2063, paragraph 21. Mr. Colvin suggested that Uber's case criminalises drivers who operate the agency model. We don't accept that. Firstly, of course, the offence of operating without a licence requires mens rea. But let's put that aside. Obviously, that's a fact-sensitive consideration. Operating is a regulated activity, but not every act of contracting by a driver will amount to operating. If the operator has accepted a booking while making arrangements under which the contract for hire is with the driver, the operator has acted as operator but failed to fully execute its obligations. But that doesn't make the driver the operator. The booking will already have been accepted. Can a driver provide a PHV? Of course, a licensed driver can drive a licensed car. He or she may own the car. And that can be an input into a service provided by an operator. The driver may or may not work and be an employee of the operator. But the scheme of protection of the Act is there must be an operator to accept the booking under an obligation to fulfil it, using such drivers or even on a subcontract. That obligation arises even if the booking is accepted on a one-off basis. Finally, section 56.1, booking and contract of hire are separate things. We agree to this extent. A risk of repeating my submission this morning, but it's brief. Acceptance is one element of contractual formation. Once a contract is formed, the contract of hire arises. Unless I can assist further, those are the reply submissions for Uber.
Thank you very much indeed, Mr. Ward. Well, we're most grateful to all counsel. You've given us a pretty little problem to think about. We'll take it away and think about it and let you have our answer as soon as